Good morning. Welcome, everyone. I'm glad to be here. The Israelis among us know that the field of class actions is a field of interest for me, and I'm glad that I was invited. Thank you for inviting me, and thank you for your kind words. And I also welcome especially the guests who came from abroad to participate in this conference. I'll start with a personal note. I was appointed to the Supreme Court on a temporary appointment in 2002 and permanently in 2003. The class action law the Israeli class action law was enacted by the Knesset in 2006. And several years afterwards, the president of the court asked me to deal with almost all the cases involving class actions that reached the Supreme Court. So I think for 5, maybe even more years until my retirement last January, I dealt with hundreds of appeals in the Supreme Court dealing with the class actions. Well, I'm not going to go into details about the Israeli law, but basically the procedure in Israel, it's a two-stage procedure. First is like what the Americans call a certification, and then the main case. So I dealt with, I think, hundreds of cases that reached the court after certification. You see, after the district court certifies a case, approves submission of a class action, then the defendant can apply to the Supreme Court and ask for permission to appeal. I dealt with hundreds of such cases, so I think I have a very good perspective about class actions, true only from the point of view of an appellate judge, not from the point of view of the court of first instance. So I can tell you that around 2006, when the law was enacted, I thought it was a marvelous idea. It was a terrific tool, procedural tool. Well, it's not only procedural, but okay, let's call it procedural tool for the time being. And I thought it's a very good idea, that it's going to deal with many problems that arise in the field of law. In a minute, I'll go briefly over the objectives of the class action. Now I have to admit, after almost 10 years, I have some reservations and misgivings, and I'll devote my short remarks to those reservations, and then I'll deal with some special features of the Israeli law dealing with the class actions. I don't think I have to go over in detail over the objectives of class actions, but I'll just mention very briefly those objectives because it'll lead me into my major reservation. Okay, the first, I think the objective is to correct the imbalance that we find in every society between large bodies, especially corporations, and the consumer or the person who gets service from the corporation. That's one objective, to deal with this problem of the imbalance. Another one, it's the under-enforcement of laws by governments. It's known that there are laws galore that are supposed to direct the operations of especially large bodies that supply consumer goods, supply services, and the governments, unfortunately, for various reasons, under-enforce the law. And the issue is how to have better enforcement. Class actions, one of the objectives of class actions to deal with this under-enforcement. And then there is the issue of small damage of injury to consumers or to people who receive services. And it's very simple. If a person thinks he suffers some kind of an injury, damage, let's say valued at 1,000 shekels, to go to court and sue the corporation may cost more than the damage. So obviously, for simple economic reasons, it doesn't make sense to go to court. These are, I think, the basic problems that the class actions have to deal with. That's the basic idea behind class actions, is to deal with these problems. Now, what is the answer? Where in class actions? Well, if you look at it, I think it's quite simple. The answer is simple. The legislature decided to take advantage, if that's the word, of a very unique human trait, and that is greed. Very simple. To use greed to solve those problems that I stated briefly. I saw that somebody laughed here, but I think if we're true to ourselves, we have to admit that that's behind it. Very simple. We know that people, or some people, like money, and we use it simply. We tell lawyers, listen, you go to court, you sue the corporation that misbehaved, and if you win, it's for you, it's a windfall. It's true that at the same time you fulfill certain lofty objectives, but behind it, simple greed. And the question that I ask is it morally proper to use greed in such a way? I suggest that you try to think if there's any other example in the law where greed is used by the legislature to solve social problems. I think there are American professors here, and they know better than anybody else about the abuses in the American system. And I don't know if you know it, but some very famous lawyers on the plaintiff side in the United States ended up in jail for abusing the class action system. So obviously I'm not suggesting that every lawyer that represents plaintiffs should end up in jail, but I can tell you frankly that I was not surprised. I was not surprised. Knowing human nature, it's obvious that some lawyers are going to cross the line. Well, there's another, we're talking about Americans, I don't know if you know it, but in some American states, state attorneys general are elected. In Israel, you just heard, now I'm heading a committee that is supposed to select candidates to the position of Attorney General in Israel. It's very different from the American states where they are elected. Now, I read somewhere, very interesting, in order to win the elections, the candidate has to solicit contributions. So the candidates for Attorney General, they go to lawyers' offices and they ask for solicit contributions. They get the contributions. Okay, the candidate won the elections. He or she are the new Attorney General in the state of Kentucky, let's say. So then what they do, they appoint one of the lawyer contributors as an attorney representing the state in a class action. I can tell the foreigners that in Israel, such a person would end up in jail. Yes, and that's maybe an extreme example of an abuse, in my opinion, but there are many other examples of abuses. I'll also mention here a very deserted rule of ethics in Israeli law. Lawyers' ethics. There is a rule in the ethical rules adopted by the Israeli bar, which says basically that a lawyer cannot finance the expenses of this client. It's not an absolute rule, but that's the law, supposedly the law. Now, I don't know if anybody did an empirical research about that point. I'll mention later empirical research done in Israel, but I wouldn't be surprised if, not in 100% of the cases, but in 90% of the cases, the lawyers finance the class action. Let's say there is need for expert opinion. You think the client is going to pay for that? Forget it. Okay, so I mentioned some abuses, and I go back to the moral question, and I seriously ask whether it's proper to use greediness, simply in order to achieve as I said, the lofty goals behind class actions. In my opinion, it's a difficult question. I don't have a simple answer. Some people may say that, okay, we recognize that it's a problem, but there's no other tool to solve the problems that we want to solve through class actions. But again, I challenge you to think of another example of a use of greed to achieve a use by the legislature, not by a private person, yeah? Legislature through the law to achieve such a goal. I have also some doubts, maybe we'll hear from the Americans who are here, whether anybody did study on the efficacy of class actions. Does it really change the behavior of corporate bodies? I have my doubts. I don't know. It would be interesting to learn about it. I think the answer should be found in a different way through imposing personal responsibility on officers. Not in every case that now is dealt through class actions, but in extreme cases of misbehavior, personal action, in my opinion, would be a much better deterrent than class action and imposing huge costs and compensation on large corporations. If people have to pay from their pockets, and if there's no insurance, obviously, and if the insurance doesn't cover it, then they may change their attitude and behavior. When it falls, the compensation falls on the a corporation, it's maybe part of doing business. And again, think about the morality of using greed. As I said, I dealt with hundreds of cases of class actions. Another field of interest of mine is what the Americans call bankruptcy and the English insolvency. I mention it because there's also an issue of collective action. It's very interesting to make some comparisons. Now, the basic rule in insolvency or in bankruptcy is equality of creditors, or pro rata or pari passu, what it's called. In other words, each regular creditor gets a respective share of the till, of the dividend is respective. Now, there we have a problem. Here is the connection of free rider. Those who deal with bankruptcy know that more than 90% of cases are brought by the debtors and not by the creditors. Not by the creditors. And it's a puzzle. You ask yourself, how come creditors don't go to court? Why is it the debtors that go? There is explanation why the debtors, but when in common law countries, it's over 90%. The debtors, not the creditors. The explanation is quite simple. From the point of view of the creditors, it doesn't make sense to invest money or to throw good money after bad money when at the end you're going to get only your respective share. That's the problem of the free rider. Years ago, I thought that the solution can come from giving a premium or a bonus to the creditor who goes to court. Now I have, after dealing with the issue of class actions, I'm more reserved. I'm not sure. I'm afraid of abuses not quite similar to those that we find in class actions. Okay, if I sum up the point, I think we should think hard if it's, as I said, if it's proper that we use greed in such a blatant way to achieve social goals. In the United States, some lawyers made billions of dollars representing plaintiffs in class actions. So some people may say, well, it's a price that we have to pay to achieve the noble objectives. Maybe. Just think about it. Now, the other topic that I wanted to address is some special features that we find in the Israeli class action law. Now, I'm not naive. I don't think, even if I convinced you that there is a serious problem because of greed, I don't think tomorrow or the day after tomorrow something is going to be changed and the Knesset in Israel or in the States, Rule 23, if I'm not mistaken, is going to be abolished, you know? It's not going to happen. But maybe we can learn something from the Israeli experience because we have, as I said, some unique features in our class action law. I'll mention the major points and then I'll go to less major points. Okay, first of all, you should know that in Israel, it's different from the United States. In the United States, the rule with respect to class actions is found in the federal procedure rules. In Israel, it's a law. It's primary legislation. It's a law adopted by the Knesset. And I think it was a good idea not to leave it to procedural rules. Even though I refer to it as a procedural tool, it's much more substantive, the whole project of class actions. So we have primary legislation. Okay, we have, and we're going to hear a lecture, talk about it tomorrow, I understand. In the law, there are special provisions with respect to class actions against public bodies, against the state, against municipalities, and other public bodies. It's a different story, different rules, and I think there's a justification for those different rules. By the way, the provisions in the law dealing with class actions against public bodies, those provisions were challenged, a constitutional challenge was brought before the court, the Supreme Court, and the court rejected the application, denied it. Okay, then we have in the law the establishment of a public fund to assist plaintiffs in financing class actions. It's little mentioned, but I think that's a pretty good idea. The trouble is that the budget is very limited. I checked the figures, and in last year, 2014, the budget in Israeli shekels was 1.2 million shekels. The committee that handles the applications received 60 applications, and they approved 28 out of them. So if you calculate on the average, divide 1.2 by 28, it's not substantial sums, but it's something. Then another special feature in the law, and that's also an important one, is NGOs as plaintiffs. One of the conditions in the law is that the plaintiff has to have a personal cause of action. But when we're dealing with certain NGOs, they don't have to prove a personal cause of action. So that's also, in my opinion, a good idea. Unfortunately, from what I understand, it's rarely used. In other words, public NGOs who can sue, who can bring class actions, don't exercise this option. Then another feature that I would mention, it's class action registry. We're a small country, not a federal state, not a federal union. It's very easy, and the director of the courts, the person responsible for the management of the courts, has to, under his authority is registry, and every class action has to be registered in the registry. It's open to the public. Now I'll move to other points that we find in our law. Some of them are of great importance, some are of less importance. Through the rest of my talk, I'll mention some statistics about class actions in Israel. We have with us Professor Alon Clement, who is here. He's going to give a talk today or tomorrow. He and Dr. Karen Margal, who used to be the head of the research unit of the courts, conducted an empirical study of class actions in Israel between 2006, when the law was adopted, in 2012. It was published, very interesting. I'm not going to go into all the details, but I have to mention a few figures, you know. But I'm sure you'll have much more to say about that important study. Okay, in our law, we have some provision with respect to settlement. I'll mention it later. But there are also provisions about withdrawal. In other words, the plaintiff can withdraw from the suit, from the action. Now, the most important difference between withdrawal and settlement is the withdrawal doesn't lead to res judicata. Okay? So if the plaintiff withdraws, then any other person, member of the class, can bring tomorrow a new action. No problem. It's different when we're dealing with settlement. When a settlement is approved by the court, it binds all the members of the class unless they opt out. Okay? Now, the study conducted by Professor Clement and Dr. Magal revealed that 60% of the cases of class actions end up with withdrawal. It's in a very early stage of the proceedings, 60% withdrawal. Now, there's another question, interesting question, about what happens to lawyers' fees in case of withdrawal. They found out that in 5% of the cases, only 5% of the cases, the court imposed costs on the plaintiff. I think it's a very low figure. I think it should be much higher figure than 5% of the cases. That in my personal opinion, is that in almost all cases of withdrawal, the plaintiff should bear the costs. Unfortunately, my opinion now doesn't conform with the case recently decided by the Supreme Court. Yes, the Supreme Court decided that if there's no show of bad faith from the plaintiff, then no costs are going to be imposed on the plaintiff. In my opinion, it's not, I go back to greed and so forth, and I'll mention also the number of cases class action brought before Israeli courts, and then maybe you'll understand why I think most of the cases that end up with withdrawal should end up also with the imposition of costs on the plaintiff. Now, there's another very interesting feature in the law, and that is the appointment of examiner to examine settlements. It's not surprising that some of the cases, those that don't end up with withdrawal, end up through a settlement, concluded with a settlement. Now, under the law, the court should appoint an examiner. So the examiner can should examine the proposed settlement and give an opinion to the court. Unfortunately, only in a small percentage of the cases examiners are appointed by the court. If you ask me why, I have an explanation. The law was enacted, as I said, in 2006. In the year after, according to the study by Professor Clement, 28 cases were submitted to the district courts. In Israel, there are 3 levels. It's magistrate court, district court, and the Supreme Court. 99, I think, of the cases go to the district court. So 28 cases in 2007. A few days ago, I spoke to the statistician of the courts, and he told me that the number of cases last year, 2014, was 1,242 cases, compared to 28 in 2007. Now, the number for until early this month, the number of cases brought at class actions, 1,167. If you extrapolate, it means 1,400 cases this year. Now, I don't know the exact number of judges who deal now with the class actions. We have today with us 2 judges from one of the district courts, so I know that they handle class actions. Even if we take a figure, and maybe it's too high, of 50 judges all over Israel who deal with class actions, you divide 1,400, you reach a figure, what is it, around 30? Okay, so think about it. And there are some judges, I'm sure, have more than 30 such cases a year. This is an unbelievable number, because most of the judges have other cases before them. Now, if you have to deal with 30 class actions a year, it's a tremendous load. Tremendous load. And as they say, one of the explanations in the United States of why so many cases end up with a settlement is that the judges, and we have to be frank, want to clear the docket. They are overburdened. That's one of the explanations, in my opinion, why in Israel, only in a small number of cases, examiners are appointed. You have to understand that if an examiner is appointed, the case is going to stretch and stretch and stretch. Recently, I read somewhere that an examiner appointed by the court submitted his expert opinion after 2 years. After 2 years. So think about the judge's docket. Yeah? Okay, so that's about the examiners, but at the same time, I think in theory, it's an excellent idea. Also, another special feature, and here I go to the Attorney General. Under the law, the Israeli Attorney General, who is completely independent, not elected, unlike the United States, in the States, yes, or even in the federal level, where he is a member of the cabinet. In Israel, the Attorney General is completely independent, and the Attorney General in Israel has to receive a notice about every settlement. And then the Attorney General can submit an objection, like any member of the class who can submit an objection. And it turns out, again from the study, that there is a big difference in the outcome when the Attorney General submits an objection. And when the Attorney General submits an objection, court does not approve the settlement without change, but the objection leads to changes in the settlement. So again, I think that's also an excellent idea to give an outside body a right of objection. Obviously, in the United States, it doesn't make sense, especially in the States. It doesn't make sense. But on the federal level, maybe the U.S. attorney, can have this right to object to settlements. Maybe that will help the situation in the United States, where the great majority of settlements are approved with no change. By the way, in Israel, we haven't reached a point yet where what they have in the United States, what is called settlement-only class action. Yeah, that's something also an invention, unbelievable invention, in my opinion. Yes, that the plaintiff and his lawyer, obviously, come to the court with the defendant with a ready-made settlement. You see, there's no case. The case starts and ends with a settlement. It's not that somebody brings an action and then during the certification stage, a settlement is reached. They come to the court and with the settlement. Well, in Israel, I don't see a very good chance for this, also from different reasons. You see, in Israel, there's another phenomenon. You read in the paper about a corporate misbehavior. It's reported in the media. The next day, there's a case in court. And also, I didn't mention another point. You see, under our court fee system, when a person brings a suit for damages, the court fee is somewhere around, it's graded around 2.5% of the sum, yeah? But in class actions, there's no court fee. No court fee in class actions. Okay, I think I'll stop here, and if to sum up, I think, as I said before, that we have to think hard about this procedural tool, the use of greed. As I said, I don't think there is a chance to abolish it, and I don't think it should be abolished. But at the same time, I think we should think hard of ways to change the system to lessen the greed incentive, let's call it that, and also to if it's a big problem, how do you reduce the load on the judges? It's a general problem. It doesn't have to do only with class actions. During my term as president, I did, I think, quite a lot to do something about the management of the system. And if the load on judges would be less than what it is today, there'll be less settlements in other cases, but also in the field of class actions, and maybe class actions would be dealt in a different and more in a better way. Thank you. If you have any questions, I'm ready. If we have time,
yeah, sure.
I'm ready to take questions, criticisms, whatever. Yes. Go ahead, please. Yes. Okay, one simple idea, I think, is to write into the law a cap on fees. We have it in Israel, cap on fees, in certain kind of tort action, those that involve car accidents with bodily injury. There is a limit, 13%, if I'm not mistaken. Yes, in the law, it's written into the law, 13% cap. And if there's a settlement in court, it's 11%. Now, I think, why not use the same idea? You lower the grid incentive. Very simple. Put a cap. It's complicated. I know it's complicated because there are so many options how the case is going to conclude that it's difficult. But if we succeeded in doing it in car accidents, why not try it in class actions? In the United States, it's unbelievable. What is it? 30%, even more than 30%. You know, and there are some, as I said before, some class actions in the United States ended up with fees of hundreds of millions of dollars. With all due respect, there is a limit. What is it? What is it? To enrich few in order to help the many? Think about it. So putting a cap, maybe it would lower the incentive. There will be less cases, maybe, yeah? But look at the withdrawal rate. When we're talking about a withdrawal rate of 60%, it means that the plaintiffs and the lawyers came to the conclusion there's no chance to win. Yeah? So I don't see that it's going to be such a big disaster if we write into the law a cap that would make a difference between settlements and cases that go all the way. By the way, if you ask, the study, I think you had about 1,400, you covered 1,400 cases in the whole study, all those years. Only 10 cases ended up with a final judgment. Only 10 cases out of 13 or 1,400 with final judgment. Okay, so I think we should, as I said, think about caps. Other ideas, maybe we can hear from you, about other ideas to limit. Obviously, if the law is written, if a provision is put into the law, the next day there'll be a constitutional challenge. Yeah, freedom of profession, in Israel, the next day, I can guarantee that. Yeah. Yeah, okay, it's true that recently the question came before the argument by the defendant in the Supreme Court was that it's improper to bring an action, a class action, if the plaintiff and the lawyer are motivated purely by greed, by the wish to make money. And the argument was if it's proven that that's only what's behind the action, then it should be stricken out at an early stage. Two of the justices didn't like this argument, and they said they didn't see any problem with the entrepreneurship, you know. And the third justice was more reserved. Then it came to a further, there was an application in our system, even after the Supreme Court decides a case by a panel of 3, you can apply to the Chief Justice, to the President of the Court, for what is called a further hearing, a hearing before an enlarged panel, 5, 6, 7, 9. So the President, the current President, my successor, she denied the application. Okay, if we say that the court should deny a class action if it's proven that only greed is behind, then we're not going to have class actions. So I understand the 2 justices. The other justice, his attitude was somewhat, with all due respect, somewhat naive, let's say. Yeah. Yes. Yes, Dr. Asif. They're humans like any other one. With all due respect, I see a big difference. I challenged you before to come up with another law that uses greed in such a blatant way. The fee system in Israel and in England is different from the United States. In theory, in Israel, the loser has to pay the costs. There's a huge difference between paying the costs and 30% of the tilt, you know, going to the lawyer. It's very different. And look at what we have in car accidents in Israel. That's exactly the point. Why did the Knesset put a cap in car accidents? To limit greediness. And you have it in other fields. Recently, when compensation to recipients of victims of the Shoah, you know, the cap was put on it. So we have to admit, we shouldn't be naive. Greed is a motivating force behind, and I'm not saying you cannot change human nature, even with laws. You're not going to change human nature. But you can at least influence to a certain degree. That's what I call for. Yes.
I agree with you that the problem is greed, but start with the defendant. So that's a remark that should be made.
It starts what? With
greed of the defendant, the one
well,
that is being brought against. But the Supreme Court dealt with the issue of fees in the Haifa judgment.
Okay.
And I think the best person to speak about what was written there is you, because you wrote it. And you said that the cap should be between 25 and 15%. So even if the legislature would say something, why should it be a lot different than what you said in that judgment?
Okay, I don't like to speak about my opinions, you know, in the court. But if you mentioned it, okay, there was a case. The case is interesting. It's interesting because we were asked to two systems, the hourly basis and percentage. I can tell you, I'm completely against hourly basis. I think it's a disgrace. All this system of hourly base, yeah, especially in class actions, it's unbelievable. You know, how do you monitor it? And that's another issue with greediness. I saw figures in the United States, how many hours lawyers claimed they worked on a case. 72 hours in one day, yeah? I mean, 24/7 multiplied by 7, yeah? So, and the court cannot monitor. There's no way. In that judgment, I said, no way hourly basis. Also, there's no connection when you set a fee system on an hourly basis. What's the connection between the number of hours and the compensation to the class? There's no connection, only percentage. Now, it's true that in that case, I think I decided that above 5 million shekels, it's going to be, or up to 5 million shekels, it's going to be 25%. But believe me, I thought about what you just said when I wrote the judgment, and I said, this is a special case. We shouldn't take anything from that case, because that case, it's a case that lasted, I think, 12 years in the courts. It went up to the Supreme Court, back to the District Court, up and down, and it's a special case. You cannot learn, and I wrote it specifically and intentionally, that the percentage that I used there shouldn't be used in the average class action. So I'm not for 25%, believe me. Yes. No, I don't misunderstand me. The argument can go that the greediness of the corporation is much greater than that of the lawyer. Okay, I don't deny it, of course, because that's, as I said, it's human nature. It's also corporate nature. Yeah, and so I agree with that, but and we have to deal with that too. The question is whether the cure is not worse than the disease. That's what I ask. Therefore, I suggested that in certain cases, we should use personal responsibility of the officers of the corporations. I think it'll be a better deterrent in some cases than telling the corporation to pay a compensation of so many millions. So many millions, it goes, it's part of the expenses, it's part of the calculations at the end, and at the end of the day, the consumers pay for it. They raise the price of the product to pay for the judgment in the class action. But if you, excuse me, oh God. If it happened in the court, God help the lawyer. Think about personal responsibility. Again, I'm not saying that it's proper in every case, a class action case, but in some cases, if the corporate officer has to pay from his pocket, not through insurance, then it's a much better deterrent.
Said there was no such thing in Israel. I was just filing an objection to such a class action settlement, which eventually was approved by the labor court here in Israel. So that's another thing.
Okay, but that's one example, one case.
But this is something that is going to happen more in the future. I know this because the lawyer.
Yeah. Well, so if you ask me, I hope the judges who sit here listen. I'm joking. But I see a big problem in a settlement-only class action. To come to the court ready-made with a settlement, what do you need the court? And some American professor, I think Martin Reddish, raised the point that in Article 3, case of controversy. Where is the case of controversy in American terms? When you come to the court, there's no case. You come to the court just so the court can certify and at the same time approve the settlement. That's a case. Where's the dispute? There's no dispute. And as I said, I hope we are not going to go in that direction. Though human nature is not any different. Lawyers in America and lawyers in Israel have the same vices and traits. Yeah. Yes. Well, because I'm very much for settlements in regular civil cases. But in class actions, it's very different. Because in class action, what does a defendant want, among other things? Wants that all the members of the class would be subject to the settlement. Okay, if you come, well, you know how many, what's the percentage of people who opt out? What is it? A 0.1% opt out in the United States? And it's human nature. You are a member of a large class, even if you get a notice. You know what? You're going to write a letter to the judge that you object. There's a different problem of blackmail. Lawyers who submit objections just to extract money. That's another problem in class actions. But it's very, very different because in a regular case, if two people, plaintiff and defendant, they can reach an agreement outside the court, settlement, that's it, finished. In a class actions, it's very different. The defendant is not going to be satisfied with the settlement outside the court when the next day another member, hundreds of thousands of members of the class can bring new actions. The whole idea there is that all members of the class would be subject to res judicata.
We are running out. Okay, last question.
Well, I think tomorrow there's going to be a talk about class actions against public bodies. I'll mention that case. It's interesting because it proves my point that Israel is the most common law country than all common law countries. And I'll explain it. You see, there are special provisions in the law with respect to class actions against public bodies. And now it works like this, that a public body, if a public body is sued in a class action, the public body can give a notice that it desists from the practice, okay? And if it gives such a notice to the court, that's the end of the case. Okay, now the question before the Supreme Court was this: what if a lawyer writes a letter to the public body before bringing class action, and the public body advises him, yeah, we desist, we stop the practice? What then? The lawyer did perform some work, achieved for the class. It's a big achievement for the class. What about his fee? There's nothing about it in the law. Nothing about it in the law. Now, a majority of the justices, they decided that even though the law doesn't say anything about it, the lawyer has a new cause of action. You understand? The public body advises before the case is submitted, we stop the practice. But they don't want to pay the lawyer. They say, what? Why are we going to pay you? You didn't represent us. We're not going to pay you. The lawyer, according to the majority, can bring an action that's a completely new invention. It's a development of a new cause of action, common law. I don't know where it comes from, if you'll excuse me, because it's not written in the law, can sue the municipality for legal fees. Even in, I'm against it. I have to admit that it shows you, I doubt that in any other common law country, a court would make such a decision. In other words, develop a new cause of action when there is a law dealing with the whole subject. Now, the problem is also from a different point, because the lawyers, when we deal with their incentives, you can't deal with a specific case. They don't expect, like when they work on a contingency basis. A lawyer works on a contingency basis. He doesn't expect to win every case. And it's the same in this issue. The lawyer who approached the municipality, I think it was a municipality, and they agreed with his argument and said, we desist. What? He's supposed, let's say he brought a class action and he lost. Well, he should get paid. So why should he get paid when he succeeded, but there was no case? And the law, there's nothing about his right to legal fees.
We are running out of time. Thank you very much for
okay, thank you.
and engaging with us.
Okay, thank you, Judge Grunis, for the interesting words. 5 minutes, okay. I think that we couldn't think about a better opening for these conventions. Okay, thank you very much.